Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable Carrie I. Enander, Judge presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Okay, good morning, and welcome to a session of oral arguments at the 5th District Court of Appeal. I've already been introduced, but let me go ahead and introduce the other panel members. Seated to my right and your left is Judge Richard Orfinger, and seated to my left and your right, Judge James Edwards. If you do have a cell phone, which I just noticed I have mine, make sure you turn it in the silent mode or the off position. Each side will have, we have 3 cases scheduled today. Each side will have 20 minutes. When the appellant steps up to the podium, if you let me know how much time you wish to save for rebuttal, I'll try to help you in that regard. The first case will be McKenzie versus State.
Good morning, Your Honors. Excuse me. May it please the Court, my name is Terrence Kehoe. I'm appearing on behalf of the appellant Brian McKenzie. This time I'd like to reserve 5 minutes, Judge, for rebuttal. Mr. McKenzie was convicted and sentenced in 2009 for 1 count of sexual activity with a minor while in a position of custodial authority. He was designated a sexual offender and sentenced to county jail time, followed by 2 years of community control, followed by 3 years of probation. Sex offender community control, sex offender probation. His probation ended in April of 2015. And the issue in this appeal is whether in 2018, whether the state could reopen his criminal case and have him designated as a sexual predator. And our argument, we have several, but the main argument is because the circuit court lost jurisdiction over the case in Mr. McKenzie in 2015, the court below erred in ruling that he could be brought back in front of it and in designating him a sexual predator.
You know, if you read the Cuevas case from the 3rd DCA and the Allman case from the 2nd, there would appear to be 2 possible ways that, you know, for the state to argue. One is if the person was still on probation or still in prison, then you'd have jurisdiction over the person because their case would still be open. That obviously doesn't apply here, correct?
Correct.
All right. And in Cuevas, both the majority and the dissent say that the legislature could grant authority to hear this case, and their disagreement is whether they had or hadn't. Would you agree with that?
No, I don't, because Cuevas doesn't discuss jurisdiction, okay? Cuevas goes off on waiver, and the bottom line in Cuevas, I agree, is could they bring him back?
Yeah, they talk about more than waiver, though. You know, the majority opinion talks about the one section of the statute, whether it's reference to subsection A1 and subsection A3 was limiting or just special venue provisions. And the dissent says you could do it, but the legislature didn't do it.
Well,
so they both talked about whether that one section in the statute granted the court jurisdiction or not.
I agree that they do get into statutory analysis, all right? But no, the 3rd DCA doesn't talk about the line of cases that says when a case is over with, all right? Whether it's a prison sentence, a community control sentence, or a probation sentence, when it's over with, the trial court loses jurisdiction. Now, Judge Altenburn refers to that when he says that we might disagree with Cuevas.
Well, I agree with you on that proposition, but Section 775.21, it talks about, for instance, someone who's been convicted of an offense which would qualify for sexual predator status in Florida, but they were convicted out of state. But when they moved to Florida, the state attorney can file a petition, the person can be designated as a sexual predator in Florida. So that is obviously not an ongoing criminal case, yet the statute authorizes the state attorney to act and the circuit court to act and the individual to be designated as a sexual predator. So I don't think the fact that there's an open criminal case or not is the sole way that a court can get authority on this. The question is, to me, is really whether the legislature granted the authority under 775.21. And the way I read Cuevas is the majority said they did, and the dissent said no, they didn't.
Well, I disagree on the issue of whether there's an open criminal case matters in his situation, because then you'd have to just put aside all the case law that says when it's over, it's over. And you can't bring him back in, you can't bring him back in.
But you'd agree with the out-of-state case, there's no open criminal case, with the out-of-state, you'd agree with as far as the out-of-state defendant or the out-of-state individual, there's no open criminal case.
That's because there is no, obviously, the out-of-state defendant, there's no criminal case open in Florida, and the only way to do it is to go into court, and they say you can open a new criminal case and go after that person and get him designated. Same thing, I think that's 5C, the first part of 5C. And the second part of 5A1 is the out-of-state, 5A1 is a civil commitment, where there hasn't been a criminal case. 5A2 is our case, which is the criminal defendant who should have been designated a sexual predator at sentencing, but wasn't. And 5A3 is the out-of-state. And I agree, 1 and 3, there's no criminal case in existence, and the statute says you can go into court. And
Well, why couldn't the legislature say that for A2 as well? I agree there's a question on whether they did or didn't, but why couldn't the legislature do it? If they can do it for A1 and A3.
If they said in this statute somewhere that regardless of whether the criminal case is over with, if someone who was sentenced in the state of Florida was not designated a sexual predator when he should have been, you can bring him back into court and have him designated as such. Right. We wouldn't be standing here, Judge. Okay? The statute doesn't say that. And Judge Shepard says that in his dissent, I realize it's a dissent, but he talks about the legislative history in 2004 where they took A2 out of what he calls this recapture section of 5C. Okay? So our argument is what Judge Shepard's is, that the recapture provision only goes to 775.215A, 1 and A3. Those are the only two things mentioned in 5C, which is what the third relies on, and the second doesn't have to, but it cites it also.
Do you believe this case is factually distinguishable from Cuevas in any way?
Both, obviously. Almond, because of the fact that you mentioned at the beginning, Judge, Almond, the guy was clearly on probation, and our argument would not, this argument would not.
Right, but as far as...
And Cuevas is a little bit iffy on this because the majority in Cuevas says that the state filed a petition before he was released, and then he was released, and then there was a hearing. The dissent in Cuevas says nothing was filed before the release from prison and all of that. But we don't have to, I don't think that matters in this case in the end. Cuevas clearly says that essentially he can be brought back into court even when it's over with. And that's the bottom line of it.
So if we agree with you, we are conflicting with Cuevas.
I'm sorry, Judge?
If we agree with you, are we in conflict with Cuevas?
No, because I take the position that if you wrote an opinion, your argument would be, it would say the trial court lacks jurisdiction, and Cuevas doesn't say that. Cuevas says he can be brought back in, but they don't address Francois and all the cases that are cited in the brief on this basic jurisdictional issue. So I would take the position that it doesn't conflict as a matter of law because you're deciding it on two different bases. It would conflict in that the result is going to be different. But I think that if the court decides this straight up on a jurisdictional issue, then it's not an express and direct conflict. But that's for another day and time. In the state's brief, they don't even mention these cases about jurisdiction. When every case, when probation ends, the jurisdiction over the case and the defendant ends. And there's nothing in the statute that says otherwise, and they don't have a case that says otherwise. And I realized, and another thing is we talk about sexual predators, and they are and offenders, and they are legislatively the people that the legislature has placed more burdens on than anybody, more than murder, more than drug trafficking, whatever other heinous crimes are out there. They get the heaviest burdens, way more probation and all that condition. But even when the Florida Supreme Court had the chance to say that in Jimmy Rice, where you obviously have a person has sexual misconduct issues, if the criminal case is over, you can't initiate the Jimmy Rice situation, okay? So it's not exactly analogous, but they're saying that jurisdiction matters, and we all know that. If you don't have jurisdiction, you can't do anything. Everything the court, and our argument is that everything the court did in 2018 was a nullity. He shouldn't have been brought into court, he shouldn't have been held a hearing, and he shouldn't have been designated a sexual predator. I'll answer any other questions, but that's the bottom line in our argument, Judge.
Any questions? All right, thank you.
Thank you.
May it please the court, good morning. Kelly Nealon on behalf of the state of Florida. First, this is not a criminal statute. So a lot of the safeguards with criminal statutes don't apply here.
Is this a civil statute?
It's, yeah, I would say, yeah. It's.
Okay, well, let's think about civil pleading 101. How do you invoke the jurisdiction? If you wanted to sue me for a traffic accident, how do you invoke the jurisdiction of the court?
Well, jurisdiction is provided under general law, under our Constitution.
No, I understand. I'm not saying that this amorphous jurisdiction. We understand that the court, in a proper case, once the jurisdiction has been invoked, I agree the court has jurisdiction to adjudicate this class of cases. My question is, if this is a civil proceeding, just like in an auto accident case, if you wanted to sue me, we all agree that the circuit court has jurisdiction to hear auto accident cases, but you've got to serve me with a complaint and a summons and give me an opportunity to respond and that sort of thing, right?
Right.
That invokes the jurisdiction of the court. Okay. How was that affected here? And under what authority, assuming that it was affected at all, under what authority does the court have to do that?
Well, under Section C.
Well, let's answer the first question first. How did the state attempt to invoke the jurisdiction of the court?
They followed the procedure in the statute. They says the state attorney shall bring the matter to the court's attention in order to establish that the offender meets the sexual predator criteria. And they notified the court that he met the criteria for being a sexual predator under the statute, just like what happened in Cuevas and Ullman and all the other cases where they have months and years later found that a person was a sexual predator that had not been designated a sexual predator.
If the defendant in this case had been subject to, say, a minimum mandatory sentence and the court forgot to do it, he goes and he does his 2 years or whatever he does, and 5 years later, the state comes back and says, oh, Judge, you know, he was subject to a 15-year minimum mandatory sentence. We want you to impose it now. Could you do that?
No, that's a criminal penalty.
But because this is just the
This is-
scarlet letter, you're allowed to do that.
Yes. Yes, and the legislature has said this is required, this is mandatory, there's no discretion involved here.
But there's got to be some jurisdiction for the court to drag the guy back in. I mean, at what point does the case begin and at what point does the case end? When did this case begin? When he was arrested,
When the information
I
was
guess.
filed? Well, yeah, when he was arrested, I mean, that's when
Okay.
speedy trial and all that kicks in.
And when did it end? Is it your theory that it basically never ended?
If he should have been designated a sexual predator and was not, then no, it does not end. I mean, it's like, if you're mistakenly released from prison, that doesn't end your prison sentence. They can fine you 15 years later and haul you back in and say you have to complete your sentence. You may be entitled to the credit for time.
That's an interesting analogy, but it has nothing to do with the jurisdiction of the court. I mean, I view this as a jurisdictional issue. Can the court just drag the guy back in off the street when there's no case pending? There's no civil case pending. There's no criminal case pending. There was no summons served on the guy.
Under this statute, yes. And okay, alternatively, if this court were to reverse, then I think we could go back and file a cert petition and say it's mandatory that he be designated as a sexual predator. It's just doing it a different way, but you're using the same statute to invoke the jurisdiction of the court.
Well, let me ask you this. Other than, the only way the state can get jurisdiction, or the court can get jurisdiction, is under subsection C. Would that be a fair statement of the state's position?
Yes, I mean, I think it requires.
All right. Subsection C refers to subsections A1 and A3, and this is an A2 situation. What do you say about that? How do we get A2 to fall within subsection C when it's not expressly referenced in the section?
Well, first off, all that is the method for FDLE or DOC to notify the state attorney. And the first sentence of that is, if the Department of Corrections or any other law enforcement agency obtains information indicating the offender meets the sexual predator criteria, but the court did not make the written finding under paragraph A, and paragraph A includes A1 and includes A2.
Yeah, and then it goes
Allowed
on.
to designate how you notify the court, and those
Right,
are
right.
two rather unusual situations.
It says if, any law enforcement agency learns this information, that the trial court didn't, follow the law previously. But then it goes on, it says the department, the law enforcement agency shall notify the state attorney, and then it refers to A1 and A3. So I'm just trying to find out your position on what we should do with the fact that they didn't expressly mention A2.
Well, I think it is because it's simply telling the department what state attorney they need to notify. In the case of where they've been a Jimmy Rice offender, then it goes back to the court that had original jurisdiction. If it's someone who moves from out of state, it's the jurisdiction where they live. It's a given that if the person was convicted and sentenced in a certain jurisdiction, that's the state attorney that's going to handle the case.
Wouldn't that apply
So-
to the Jimmy Rice situation under A1? That it's a given, it would go back to the prosecutor who prosecuted the Jimmy Rice case?
I think it could, but there might be some questions. Do you do it down in where the Jimmy Rice Center is located? Who does have jurisdiction over the defendant at that point? I think there could be questions about that, and this just specifies exactly where. Because the next sentence is, the state attorney shall bring the matter to the court's attention in order to establish that the offender meets the sexual predator criteria. So I don't think this statute was written to allow people that were convicted and sentenced but didn't get Jimmy Rice or didn't move in from out of state to not be designated a sexual predator.
Let me ask you this. Under A3, the state has had no prior opportunity to have the individual designated as a sexual predator. They were in another state, they moved to Florida.
Right.
All right. Under A1, the Jimmy Rice Act, the state had, one opportunity to have them designated?
That's sentencing. That's where it's...
Would you have sentencing in the Jimmy Rice Act, or what do you have there?
Well, their original sentencing is where they would be designated a sexual predator.
Right, but then why do they even reference the Jimmy Rice proceeding?
Well, I believe it's in the case of those people that weren't designated a sexual predator.
I mean, it could have been someone convicted before 1993 or whatever date, and then had a Jimmy Rice Act subsequent to that date, right? I mean, that's one.
Sorry, I just.
It could be a situation where someone was convicted of an offense before 1993 or whatever the date is, and then had their Jimmy Rice proceeding after that. They can be designated as a sexual predator.
Sure.
So so the state would only have one opportunity there. That would be at the Jimmy Rice proceeding.
Yes.
But in this case, how many times did the state have an opportunity to request that the individual be designated as a sexual predator? You have the sentencing. Did you have time before, did you have the opportunity for an appeal? I'm saying that this individual he got sentenced. No one designated him as a sexual predator.
Right.
There was an opportunity for the state to argue he should be designated as a sexual predator at sentencing, correct?
Well, it was mandatory that the state.
Right.
It was mandatory that the trial court impose a sexual.
But it didn't
predator
happen.
finding. Correct.
Okay. Was there an opportunity to do a post-sentencing motion before it went up on appeal?
Yes.
Okay, and the state didn't take advantage of that, and the court didn't take advantage of that.
I don't know. I don't think there was an appeal in this case. So.
Okay, but there was an opportunity for an appeal.
Yes.
Okay, so in the other situations, I'm just saying the state had one opportunity to get the sexual predator designation. Here, they had at least three. Is that a possible reason why the legislature didn't include Section A2 in subsection C?
No, I don't think so. It's not a matter of the state having the opportunity. It's a matter of the legislature requiring that these people be designated as sexual predators if they meet the criteria.
So if the person's 89 and on their deathbed 60 years later, you'd have to make the same argument that the state could come
Yes.
in and do that.
Yes. Be it 5 years later, 10 years later, 30 years later, yes. I
But
think
the
statute-
legislature could decide they didn't want to do that. They wanted,
I-
the legislature could decide they wanted to draw the line somewhere.
I think it's clear from this that the legislature did not draw the line in that place. They said the state attorney shall bring the matter. And again, the whole purpose of this statute is to be in compliance with the Adam Walsh Act. I mean, this is not just a state law requirement. This is a federal law requirement, too. So I don't even think that Florida could opt out of if the prosecutor and the trial judge missed it at sentencing, then they would never be able to go back again and do it.
Well, if it's a federal law requirement, would you really need Section A3 because the person should have already been designated as a sexual predator in a different state?
Well, maybe they were, but they also have to be designated in Florida and follow the Florida requirements and be registered in Florida so that Florida has access under its own registration system. And again, this isn't a criminal statute. We don't have to strictly construe this in favor of the defendant. There's no rule of lenity here. And I think that clearly the intent of this statute is to comply with federal law, and that if someone was not designated a sexual predator at sentencing and they qualify as a sexual predator, then they have to be designated as such whenever it is determined that they are a sexual predator. I think that's what the Quaves case holds. I would ask this court to follow that, find the statute definitely requires that, and affirm the finding in this case.
Any other questions? All right, thank you.
Thank you.
I just have a couple of quick points. One, I think this state's argument that the case never ends doesn't have a basis in law or common sense. Every case, criminal or civil, eventually ends. And this statute doesn't leave this case open-ended forever and a day, whether it's 2018 or 2035.
Is it a criminal case?
Pardon me?
Is it a criminal case? Well, we have, what you all are arguing to us as far as the underlying case, was that a criminal case?
This is a civil issue, remedial civil issue. All the cases have said that. But they are imposing it, and it could have been imposed, this civil remedial punishment, status or whatever you want to call it, could have been imposed in this criminal case. But the mechanism they used is a criminal case that had been closed. And to go back to Judge Orfinger's stuff at the beginning, how does a civil case start or whatever? This criminal case, under any case has been closed.
Why do we have to view it as a criminal case? I mean, didn't the state attorney file a petition? Just happened to file the petition with the circuit court that handled the criminal case, but that doesn't mean it has to be a criminal case.
Well, I don't know what the state could have done otherwise. That's not, I don't have to decide that today. You all don't have to decide that today.
Well, I'm trying to figure out if it's a civil case or a criminal case.
Well, they invoked the jurisdiction of the criminal court to impose a civil penalty that could have been imposed in 2009. That's what they did.
And what's
The actual procedure they followed, if you look at the order, they had the defendant before them for sentencing. There is no sentencing in anything other than a criminal proceeding, is there? You don't get sentenced in a civil proceeding, do you?
I understand that, and if you look at the 2018 order, it says that this is being imposed at sentencing, which is, of course, a fiction. The state prepared a form order and gave it to the judge, and he signed it. This isn't being imposed at sentencing. It's being imposed 3 years after the...
Oh, I get that, but I'm saying this is not being treated by the state or the court as a civil matter. It's being treated as a criminal matter.
Absolutely.
We're saying we're sentencing you.
I agree 100%. This is entitled State v. McKenzie Criminal Case Number X, all right? And Judge Orfinger, you talked about how it initiated. Number one is the notice that was filed by the state, and then, I don't think this is in the record, they served a subpoena on him to appear on a certain date, and that's when the hearing took place. So that's how they brought him into court in 2018 in a criminal case.
How did they bring him in Cuevas? Did they bring him in the criminal case or a separate proceeding?
I'm sorry?
In the Cuevas case, did they bring him in a criminal case or a separate proceeding?
It appears clear to me, both Cuevas and Allman, they brought him in the criminal case.
Okay.
Cuevas,
So in this
there's
case,
nothing in Cuevas, I'm sorry.
they got him to court by virtue of a subpoena issued out of the criminal case?
Exactly, Judge.
An
The
interesting way
subpoena
to...
has the same style of the case as every pleading that's before this court. State v. McKenzie, criminal case number, et cetera. Which, of course, to me is a nullity because the case no longer was open and current in 2018. But that's how they got him into court. One, a notice, and two, a subpoena. So they did both things. So number one, I wanted to mention the thing about case never ends. Number two, I want to go to Judge Evander, your thing about when did they have the opportunities. Number one, could have made it part of the plea agreement. Number two, they could have stood up at sentencing and said they wanted it. Number three, they had the right to appeal it because it was mandatory, and they would have won on appeal if they took a direct appeal. Number four, all the time from 2009 to 2015, when he was still under the state's thumb, Department of Corrections. If you look in there, Department of Corrections, before this was over with, they went back to the judge, obviously on a different issue, but they said, probation's about to terminate. We want to know if we can because he hasn't finished counseling. And the judge said, if he's substantial compliance, you can. So this is a case where it's clear that DOC reviewed it right before his probation was going to end, and it never came to their attention or they weren't concerned. They let it end, okay?
Well, let me ask you this.
They asked for it to end.
If they brought it improperly in the criminal case, and we agree with you in reverse on that basis, can they refile? And bring it as a, legend that it's a civil proceeding under subsection C, 5C?
Well, then that would be litigated and we'd see if that could fly. But the issue before before the court now isn't how could they do it in the future. It's
All right, so are you asking for a bigger picture approach, or just that on these facts alone, they brought it the wrong way, reverse, end of story?
I'm asking the court on these facts because they're different from Almond and Cuevas. that the court should reverse and say that the court lacked jurisdiction to proceed in 2018 on this matter.
Okay.
Thank you.
All right, thank you both.